Hi, everyone. Welcome back to this episode of Estate Expectations. I'm your host, Elizabeth Pickle, and I am beyond delighted today to have my esteemed colleague with me. This is Julia Cronin of the law offices of Julia L. Cronin, and she's a superb, one of those neuroscience rocket surgeon kind of attorneys who let me just say, when Julia and I belong to several different kinds of social media groups for estate planning women. And whenever Julia answers a question or makes a comment on these social media posts, let's just say I take a snapshot of that and I squirrel it away in my files called, Liz, you need to learn more about this. And so it's just such an honor and a pleasure to have Julia. Today, we're going to be talking about estate planning for high net worth individuals, as well as navigating the cryptocurrency frontier. And so if you are into crypto and you're really nerded out and geeked out like I know we are, this is the episode for you, because it is an asset that requires immense intention with respect to how it's transferred and how it's protected for beneficiaries. But first, Julia, thank you so much.
Good morning, Liz. I'm happy to be here with you.
Are you happy to be in Old Town Scottsdale, Arizona?
I'm happy to be wherever you are.
Oh my God.
And
do you see?
We're having a great time in Old Town Scottsdale.
Good. And you're here with your beautiful family, I know right now. And you're not on vacation, are you? You're just kind of...
It's fall break. So we came on Thursday, and the kids they did the wave rider or the whatever. I keep calling it the surf rider, but I think it's called the wave rider or something. Mm-hmm. And the lazy river, and...
Great.
They've been living their best lives.
Well, as they should. So it's great to have you here. And you came just in time for the season. This is when we're coming into our fantastic weather, although I think it's going to be warm this week. But
it has been fabulous. We have had the best time.
Right. And how is it now in Colorado? It's starting to cool off, right?
It is fall. It is distinctly fall to winter now. There's a long time that's like summer to fall.
Yes.
And then there's sort of a true fall, and then it's fall to winter.
And it's fall to winter, exactly.
We flew in on Thursday, and they got a foot of snow in Vail already. So we are avid skiers, and we are very excited about that.
You guys, that's
but
fabulous.
if you're not leaf peeping the first and second weekend of September in Colorado, you better be flying to the Northeast.
Yes, indeed.
Where are you from?
Exactly. Well, in Maine, we ski on ice. So, it was, I enjoyed it, but it's a whole other world out here with the powder. I don't have any powder skis yet. So
I can help you with that.
Oh, thank you very much, my friend. So as I mentioned, we're going to talk about high net worth estate planning. And, I want this to be manageable for our audience. So kind of like bite-sized pieces so that people can really understand what it means. What does high net worth mean? And it might be self-explanatory, but in case it isn't, can we define, what is considered to be high net worth and the importance of tailoring estate planning for individuals with significant assets?
Sure. Now, I will start with what I always start with, the disclaimer, which is that anything I discuss here is not legal advice for any particular person.
Amen.
And they should consult with a licensed estate planning attorney and or business attorney in their jurisdiction. Yeah. And so I'm happy to talk broadly about principles and ideas that, the general populace likely wants to think about. But please don't take anything out of context, and please don't self-help.
Very well said. Yes. Thank you, Julia.
And so Forbes last year identified kind of the sort of rich. They defined the rich as the top 1% has approximately around $11.7 million, I think, last year, which is coincidentally very close to what the exemption amount was.
Exactly.
I'm sure there's no correlation there at all. But there's really, I tend to think about it as kind of people with like in tranches of like up to $20 million, which is very, very wealthy. Then there's up to sort of $40 million. and above. I mean, I have clients that are centimillionaires.
Yes.
And so with each of those levels of wealth, there are some of the same considerations and some different considerations.
Interesting.
And so I sort of start back up to sort of ground zero, where like, what is like estate planning, which I know you have covered many times, but it's a plan to take care of your assets. I call it everything from your stocks to your socks.
I love it.
During your life and after death. And so what's really important to me, no matter what we're talking about, is that my clients enjoy their life. And part of enjoying their life is really that peace of mind that you get from having a plan. You know, all of us could have an incident at any time, at any day, when we are not able to make decisions for ourselves. And I could give you many stories that are very, very moving about sudden changes in people's circumstances. And so I do think that, the best day to do your estate plan was yesterday.
Yes.
And the next best day to do your estate plan is today, or, in the very near future. And so with that estate planning, there is, as you know, kind of planning for your assets and planning for your well-being during your life. And so I'm going to get forward to high net worth planning, but, we really look at taking care of your assets can be done through a will or a trust. I like a trust-based plan for reasons that we can talk about.
Yes.
And your healthcare documents, as well as your financial power of attorney, right? So who can step in and take care of your financial affairs if you're alive and incapacitated? If you're dead, we can make plans for your assets.
Yes.
But what I really am passionate about is making sure that my clients feel that they're taken care of during their life.
I love it.
And I work with a lot of entrepreneurs. And so, a lot of them are founding entrepreneurs. And so what happens to their business if they're not there that day, it's actually really hard. It's almost inconceivable for them. And as you know, my husband is an entrepreneur as well.
Yes.
And so we, for our own plan, have had to think about like, what if he wasn't there?
Yes.
Which we hope he's there for a very long time, because he's wonderful and I love him so much. But so if we look at your estate plan sort of from the foundational, so like if your revocable trust is a will substitute, and it can plan for all of your estates, whether you have a taxable estate or not. I'm going to come back and define a taxable estate in just a second.
Excellent. Thank you.
And so it can plan for all of your assets. And so a trust is really a set of instructions. And so there are three parties to a trust.
Yes.
The person that makes the trust, who's called the trust maker, the grantor, or the settlor, depends on which state you're in. The person that administers the trust, who's called the trustee, and the beneficiaries. Right. So with a revocable trust, Elizabeth, if we were designing a revocable trust for you, you could be fill all three of those roles for yourself from inception.
Right.
But as the trust maker, you really write those instructions.
Yes.
And so we work closely together to design that trust for you. I mean, almost nothing I do is cookie cutter of like, everybody, you get this and you get this. Like, it's really who would you want to make these financial decisions for you or for your children or for your business? And so we work through that on a personalized basis, and we create those tailored instructions. And
let me just interject,
Please.
because I want everyone to pay close attention to what Julia is saying about the way that she focuses on her estate planning. It is to prioritize you, the trust maker, the grantor, and what are we doing to enhance and protect you during your lifetime? Okay, thank you.
And then we write those set of instructions. And for the most, it's not a very elegant metaphor, but it's really like those instructions go on the side of a bucket. And those instructions control what's in that bucket. Yes. And so if we don't transfer any property into that bucket, the instructions are there. But hopefully you have a pour over will. And if we haven't transferred anything into the bucket during your life, when you pass away, it'll say pour everything into the bucket, which will still have to go through probate, as you know.
Yes.
But we really want to transfer it's called funding your trust or asset alignment. And we really put the assets in the name of the trust and sort of putting those assets into that bucket. And that's so important. Every time I talk about estate planning, it's so important to make sure that your assets are in the name of your trust. Yes. Because when do you really need that trust to work? If you could tell me what day you're going to become incapacitated, then I would say, like, let's make sure the day before we have all your assets in there. But we don't know.
Right. Or can you imagine having a date of death? That would be creepy.
It would be very creepy.
It would be creepy.
But I could do a lot of planning if I knew exactly when someone was going to die. You sure could. So we have that bucket with those assets. And with the revocable trust, that bucket is open.
Yes.
So in terms of like ownership, the trust is the owner of record. But in terms of like tax planning purposes, you are the person who created the trust and put the assets in the trust is still deemed to be the owner of those assets. So you can put assets in that bucket. You can take assets out of that bucket. Typically, you're the trustee of your own trust. So you spend those assets on whatever you want to spend those assets on. If you become incapacitated, the day you become incapacitated, whoever is named as your successor trustee, sometimes that's your spouse if you're co-trustees, right? But sometimes I have clients that are not married or one spouse is already incapacitated, right? So whoever they've named as that next person takes control of that bucket. But they don't get to spend the assets in that bucket on whatever they want to. They are bound by a fiduciary duty to follow the instructions in the trust that we designed together.
That's a buzzword, fiduciary duty.
And so they have that fiduciary duty to follow those instructions. And so, again, during your lifetime, if you make a revocable trust, you can put assets in, you can take assets out. You follow the instructions, you can change the instructions. You can say, I want to get rid of these instructions altogether and create brand new ones. You have the power to do that. Once you, as the settlor, grantor, are incapacitated or dead, but incapacitated in life, the trustee's obligation is to follow those instructions. And so why do we care about any of this, right? So we're back in the estate planning context. We're talking about a revocable trust as one part of your overall estate plan. When you start to get to high net worth planning, what we look at is every person under the federal tax code has a certain amount of exemption that's allowed. So you're allowed to give away a certain amount of gifts during your life or after you pass away, and the federal government will not impose additional tax on that. So there are actually three kinds of those taxes. One is called the gift tax, one is the estate tax, and one is called the generation skipping transfer tax. Fortunately, it's all a unified amount. So you have today, what is today? Today's October 16th.
Yes.
Today you have $12,920,000 of federal lifetime gift exemption and or estate exemption, which means that if you give away $12.92 million worth of assets during your life, you won't have any left at death. So it's one pot of that. And then your generation skipping transfer tax exemption applies if you give a gift to someone who's more than one generation below you. So like if a grandparent gives a grandchild $1 million, even during life, not even in trust, just writes a check for $1 million to a grandchild, they would need to use some of that GST exemption as well as their lifetime gift exemption to cover that $1 million gift. So again, why do we care about any of this? So when you pass away, like let's say I have a client whose estate's worth $5 million today. Let's say they're single and they have 3 kids, okay? So at $5 million, they have $5 million worth of assets. So this is when I use my hands a lot. So if they have $5 million worth of assets and $12.92 million worth of exemption, they have enough exemption to cover all of their assets. So they might not want to give away any assets during their lifetime, if that makes sense. Yes. So they have enough exemption to cover that so they can transfer those assets at death without incurring any transfer tax at that time, whether it's gift tax during life or estate tax would be after they passed away. So when we think about who might be interested in doing, people call it a variety of terms. There's one thing estate planners are known for. It's acronyms and trust names, and the same trust can have several different names depending on whose marketing firm named it, to be honest.
Yes.
And so, but what you really want to be clear on is what it's going to accomplish. And so this revocable trust that we talked about it's an incomplete for your lifetime. I mean, you can put assets in or take assets out, but it does nothing in terms of tax planning during your lifetime. Right. It can, if we include some tax planning provisions inside that trust, like if you have like a charitable lead annuity trust that's inside the revocable trust.
And could I ask you, that tax exemption, will that change? Can that change? Can that sunset?
Well, it's permanent until the next Congress decides to change it. And what's happening right now is the current exemption is $5 million until 2017, when the Tax Cuts and Jobs Act was passed in 2017. it doubled the amount of the exemption from $5 million to $10 million for a limited window of time. So currently, the exemption amount is $10 million adjusted for inflation, which is what gets us that $12,920,000. On December 31st, 2025, that provision of the Tax Cuts and Jobs Act sunsets, so that available exemption amount will cut in half. It will go back to $5 million adjusted for inflation. So, on January 1st, 2026, the same person will wake up with maybe about $6.5 million of exemption, depending on the inflation adjustment, but $5 million adjusted for inflation. So I think of that exemption amount as like a depreciating asset now, because it's really use it or lose it. And so Congress has told us, if you make gifts up to the full amount of the exemption amount, $12,920,000, before December 31st, 2025, and then the exemption does in fact come down, they will grandfather those gifts in.
Yes.
But if you haven't used your exemption by that period of time, then it will be back to the $5 million adjusted for inflation as of January 1st, 2026.
And for a single individual, I don't think it takes, maybe if you're a business owner, maybe it doesn't take too much to get to that exemption amount, that rate, that $5 million. That's threshold is not as high.
It's not as high when you consider all of your assets.
Exactly.
Right. And so I have some of the financial planners I've worked with clients that have significant business interests.
Yes.
They tell them above the amount of their exemption amount, they're in business with the federal government. The federal government is their 40% business partner. Many of my clients are not very fond of that.
Right.
I mean, it's just that once someone passes away, there will have to be a resolution with it. An estate tax return will have to be filed. The assets will be valued and disclosed. Sometimes there are certain things that can be done to make that estate tax due over time, but not in every instance. I mean, there are people who have to liquidate assets, and there's,
and I think, and that's a really good segue into how is that going to affect, maybe the family members, the children, blended family, and then wealth transfer. If, as you say, assets may have to be liquidated.
Hopefully, we have a plan for that.
Right.
I mean, that's
right.
We tend to plan for our clients. So most of our clients adopt the philosophy that the estate tax is optional. It's voluntary, because not that paying your taxes is always obligatory, but we encourage our clients to not pay $1 more of tax than they're legally obligated to pay. I mean, we are ethical and we follow the rules, and I like my bar license. And there are tools in the Internal Revenue Code that would allow you to zero out that estate tax exposure. One of those tools, as I was talking about before, is called a charitable lead annuity trust. And so sometimes within the revocable trust, we have buried in there a testamentary, which means it only takes effect at death, charitable lead annuity trust, which only says if you have assets that will exceed your available estate tax exemption, then instead of paying 40% estate tax on those assets before they go to your beneficiaries in this same, it's officially immediately, but really it's within the period of the audit and paying the taxes. So it could take some time. The assets go to what's called a charitable lead annuity trust. And that's a kind of trust, again, a set of instructions that is irrevocable at that time. And it's a split interest trust. One interest goes to the charity, and the remainder interest goes to your beneficiaries. So often it's the kids. And so with the charitable lead annuity trust, let's say it gets $1 million worth of assets. There's math at the time based on the federal interest rates at the time, the 75/20 rates at the time, and an annuity amount is paid to charity every year, and that's not voluntary. I mean, that annuity amount must be paid every year to comply with the terms of the trust. Right. The annuity amount's paid, but the theory is the assets are invested, and so they continue to grow. Yes. So you have payments that are made to the charity every year, and at the end of that term, we can make it so that it's zeroed out the federal estate tax. Often that takes, make that term 20 years or 22 years. At the end of that term, the charity has received often a significant amount of money. And then the remainder goes in trusts for your children. Yeah. So it depends on how much wealth we're talking about. A lot of our clients have they have already made substantial gifts and trusts to their kids.
Yes.
And so this additional amount, number one, they're actually very interested in doing good in the world. And number two, they're okay to have, 20 years after they're gone, their kids can get some additional return. Now, there are factors. The interest rate, often we'll have a bailout provision because if the interest rate's too high, it can be hard to overcome the charitable bequests and still get enough return in order to have anything left for the kids. So sometimes we'll have a bailout where if the interest rate is just way too high and it would be really hard to have the charitable payments and a remainder amount, then we can say, like, don't do that.
I love those baked in provisions and you mentioned before, depending on what the exemption rate is, that you can kind of flip the switch, whether or not you want to even create we call the CLAT, right?
That's a TCLAT. That's a testament.
That's a TCLAT. Okay.
But so if that doesn't get created, then that estate tax would be due.
Gotcha.
Right. And there's not really a switch. Nobody's making that decision at the time.
Yes.
We bake that into the trust.
Right.
And so we would need to amend the trust before somebody died if they wanted to change their threshold on that. But a lot of our clients they're charitably minded anyway.
Yes.
So they're happy to make those donations to their charity of choice. And then the remainder goes to their kids. The other thing is the charity, right? For some of my clients, the charity is their own private foundation. So it's putting those charitable funds into the foundation that's been set up during their life to establish the purposes of which they're really committed to.
Fabulous.
And these are all in compliance with IRS rules.
Yes.
Or if they haven't done a private foundation, it can go to a donor advised fund. And then their children are the advisors. And so, a classic example is you have, children that are physicians or something. And the funds go into the donor advised fund. Like every year, the hospital has some kind of a fundraising drive. And so, the child gets to be very generous with funds from the donor advised fund and make a contribution to the hospital, which also increases their professional esteem because they're able to, bring more resources to bear to the hospital. And so it's another way that you can sort of enhance the quality of your beneficiaries' lives.
Talk about legacy planning.
Long after you're gone and do good in the world, right?
Yes.
So it serves multiple objectives.
Incredible. Oh, so I guess if there's more that you want to say, and there's so much more you could say, please do. But I would love to touch on the issues around cryptocurrency because that seems to be it's a cutting edge issue right now with planning, and it needs to be treated very delicately.
There is, and I would love to address these crypto questions. Can I go back and talk about completed gift grantor trust?
Yes,
first?
Please.
And so I sidebarred myself by trying to do a little bit of foundation, which your audience may already know some things about, but I can't help myself. I feel like
it's important to reiterate these concepts.
I feel like I have to go from so at the beginning is kind of that foundational level estate plan. And then when you have clients that are looking at taxable estates, right? So let's say you have a married couple that currently has a $20 million estate, but maybe they're only in their 40s. That will grow over time. Or you have a married, clients that have an estate tax exposure right now. If you have estate tax exposure today, meaning either a person who has over $13 million of assets or a married couple that's over 26, they likely want to consider some of these strategies before 2025. And I am like the lowest pressure planner in the world. I really believe in my heart that I am in the peace of mind business. And so I think people should do planning when they're ready to do it. And I feel really passionately about that. But also, don't wait too long, right? And so I'm not sure there'll be enough time in 2025 to do all the advanced plans that people are going to want to do. I feel like it's going to start being in the news every day that the exemption is coming down. And there will be, so I am in the planning business, not the predicting business. And so
well said.
There will be discussion about, is Congress going to extend the exemption level at this level? Are they going to let it sunset? I don't have those answers.
Right.
All I know is what's in the law right now,
correct,
which is that the exemption will go down on December 31st, 2025. And there have been years when there was no estate tax. There was a year when they wiped it out altogether, right? So it is not good planning to just try and play with the political football that Congress has with the estate taxes. But I will say that we try to build in as much flexibility as possible with our plans. And so It's very difficult from a consumer perspective, I think, to tell the difference between one stack of papers and another.
Yes.
Because it's this person wants to sell me a trust that's X amount of dollars. Somebody else is telling me Y amount of dollars. First of all, I never start with the amount of dollars. We almost always do. It's a little bit like building a house. If I have a plot of land and you want to build a house, first I need to understand what is the local regulatory environment, right? Like how much of this land can I build on? What's under the land? Mm-hmm. What kind of house do you want to build? Do you want to build a ranch? Do you want to build like a 3-story, mansion, craftsman mansion with a pool and a hot tub? Not that I've thought about this, but, you have to really start with where are we?
Yes.
And often when I have clients that have significant assets, it's what are the business interests? How are they held? Is it an S corp? That's a very different situation than it is an LLC taxed as a partnership. I mean, what does the client own? Mm-hmm. What are the value of those assets? Mm-hmm. We don't always have to have the valuation first, but we need to have a relatively close approximation.
Yes.
Because if you're going to make completed gifts, we're going to need an actual valuation because we want these things to hold water, not just that we did it on paper and the IRS will look the other way. That is not not a plan.
Nope.
That is a fantasy.
Not a good plan.
That's a fantasy. And so I do think that this is going to be in the news about whether or not the exemption is going to come down, or is it going to stay the same, or is it going to go up, right? Is the level of wealth that generally increases, is the exemption going to rise? I'm not sure about that. What I can say is if a person has a taxable estate now, and I have clients that have well over as taxable estates, the most exemption I know they're going to have is right now. And if we do a completed gift irrevocable trust, which I'm going to talk about in a minute, a grantor trust, it gets those assets out of their estate today at today's value, often with a valuation discount, which is legitimate IRS policy. Mm-hmm. And then all the appreciation is outside of their estate. And so this will come back to crypto in a minute, but all that appreciation is outside of their taxable estate. And so when people are not quite ready to get started yet, we often will say, start with, some people call them a baby trust or a starter trust, where some clients come in and they're ready. They want to use their full exemption today. They want to create an irrevocable trust, which I'm still going to get to, and transfer $12.92 million worth of assets in today and let's go. Some clients are not there yet. But they I do encourage people that are leaning in that direction or have that kind of estate tax exposure to get started. And we can start, we don't have to fund a trust with $12 million today. We can fund a trust with $500,000. We can fund a trust with $20,000 while you think about it. The one thing that I can't do is make more time happen between now and December 31st, 2025. And so with that completed gift irrevocable trust, we talked about irrevocable trust. An irrevocable trust is a trust that you officially are not allowed to change during your lifetime. Now, modern trust theory, there's a lot of flexibility in there. Yes. And so we almost always include the ability to remove and replace, for the grantor to remove and replace the trustee. There's no question. There's also, we can make it directed trusts, which depends on what state you're using, right? And so when you're talking about completed gift irrevocable trust planning or incomplete gift irrevocable trust planning or non-grantor trust planning, the state in which you park that trust is really important. Yes. So there are states with favorable income tax rates and favorable trust laws and favorable asset protection laws that will go on forever. I mean, the Nevada rule against perpetuities allows the trust to last for 365 years. Wow. Wyoming allows a trust to last for 1,000 years. South Dakota allows a trust to last forever. There is no end to a South Dakota trust. All three of those states that I just mentioned also have 0% state income tax return. So that means if assets are owned in that irrevocable trust in a non-grantor trust, which we'll talk a little more about, they have federal income tax exposure, but they don't have state income tax exposure so long as assets aren't consumed. If assets are consumed, if you get a distribution, a beneficiary will be taxed whatever state that they live in. Sure. So if you live in California, there's going to be federal tax paid in Nevada, and then the beneficiary is going to pay California state income tax level. And there are some unfriendly rules like throwback tax rules. So you have to be careful, and you want to know what you're doing. You want to hire a trustee that knows what they're doing. Right. You want to hire a planner that knows what they're thinking, but you want to avoid kind of traps for the unwary just by not knowing that distributing more than this year's income from a non-grantor trust to a California beneficiary is going to incur throwback tax up to 5 years.
Okay.
So with those completed gift trusts, you make the trust and you actually have to give away the property.
Yes.
And so that's part of the hardest when we talk about a baby trust. Sometimes people are not ready to give away $1 million and give up control of that asset. I mean, it's most of my clients have built their wealth themselves. And so it's really, how much is enough, first of all, which is, we're not really here to talk about psychology today, but it's a great question.
Oh, yes, it is a great question.
It is, when do people feel wealthy? I can tell you there are clients with $40 million who don't feel wealthy, with $80 million who don't feel wealthy. Most of them have built their wealth, so they understand how hard it was to build it. And I think I hypothesize that they feel that if they lost it, it would be really, really hard to build it again, which is true.
Very true.
And a lot of entrepreneurs, they have sort of one, they can make it through one time, the gauntlet, right? But they've learned so much. And then going in a second time some people are serial entrepreneurs are really successful at it. But
yes,
that's, again, a different topic. But no matter what your asset, if it's $20 million and you want to create a trust with $1 million, let's say, you can create a completed gift irrevocable grantor trust. Means there is a wrinkle between the income tax rules and the estate tax rules. And so you will have to pay income tax unless you're in a 0% state income tax jurisdiction, but you will still have federal income tax on income earned by assets, whether it's in your name or in the name of the trust. There will be income tax. Whether there's, I was just thinking about something in Nevada, so I've lost my train of thought for a second, but you will have income tax. Whether or not you have to pay estate tax depends on your amount of exemption amount. And so if you give away, let's say you have a $20 million, I'm a single person, I have a $20 million estate. I create a grantor trust and I fund it with $1 million. So now in my personal name, I still have $19 million. In the irrevocable trust, which I've given away, there's $1 million. Typically, we don't gift cash to that trust because there's no discount really on cash. And so if you gift $1 million worth of business interests, let's say, to that trust, the business has to be valued. And in performing that valuation, a professional valuation company is going to look at the operating agreement or the shareholder agreement and look at what are the restrictions on this. And if you're giving away a minority interest, there are typically discounts for this because let's say it's a 5% interest in the company. My 5% interest, number one, often I can't sell it on the open market, as the trustee would be the person who would sell that, but I can't sell it on the open market. I can't decide whether or not I'm going to get distributions. I can't decide what the company's going to invest in. So it's value that accrues to you, but you can't really control it.
Right.
And so because of that, the IRS says it's not worth 1-to-1. It's not worth $1 million. It's probably worth some discount. I'm not the valuation person, so I don't perform those valuations, but there are legitimate discounts. Sometimes we compare it to tomatoes and a can of tomato paste, right? If you have 8 tomatoes, it takes up this much space, right? A can of tomato paste takes up this much space. So if the valuation discounts, you can give away a sliver of the can of tomato paste that once it goes back in here, if the company is sold and you have the irrevocable trust interest and then what's in your estate, it's worth the fair market value.
Yes.
But if you were trying to sell it to somebody else, it's not really worth a $1-to-$1. And so all that is to say, if you gift $1 million worth of business interests to that trust, you're sort of getting more than $1 million worth of value out of your estate, if that makes sense, because of those valuation discounts, which have to be done on a fair market value basis. It's what a reasonable buyer would pay and a reasonable seller. So we're not overinflating the price because we want to say it's worth a lot, or underinflating because we want to use less of our exemption. It's really, you want it to be legitimate and you want this to hold water.
Of course.
And there's a whole science to valuation as well. I mean, it's not cash and it's not marketable securities. So there is usually a range. And let's say you make $1 million worth of business, a gift of $1 million worth of business interest to that trust. We want that to be drafted correctly, potentially with some, valuation adjustment clauses in there, so that if the IRS challenges that valuation, then you still want to achieve your outcome.
Absolutely.
And so the IRS can, once you make that completed gift of $1 million, then a gift tax return needs to be filed by either April 15th of the next year or on extension October 15th. And when that gift tax return needs to be filed, starts that 3-year statute of limitations running on the valuation.
Okay.
And so you can do all this work. We can create a trust. We can get the business valued. We can gift $1 million worth of business interests. Let's say today is October 16th. If we do that today, October 16th, 2023, the gift tax return would be due April 15th, 2024. If you filed it, not an extension, April 15th, 2024 would start that clock running, 25, 26, 27. So like April 16th, 2027, you would feel like, sweet.
Right.
The valuation is, but that's why proper disclosure is super important. Because you want to get that statute running on the valuations just to get that sense of sort of finality. So with those completed, I'm going to go back just to talk about the grantor trust for 1 second, which is there's a wrinkle between the income tax rules and the estate tax rules. And that is, if I create a grantor trust for the benefit of Liz, and I create the grantor, I'm the grantor, I create this completed gift trust. Let's say I situs it in Nevada. So I get a Nevada situs trustee so that the trust can live in Nevada. And let's say I've gifted $1 million worth of business interests to you. And that business generates $200,000 of income for the trust for next year. So in general, the trust has $1 million of interest. It now has $200,000 of cash next year. Because of the grantor trust rules, they're written such that I can continue to pay the income tax liability on the income that's earned in that trust. And so the trust earns $200,000 of income. I, the grantor, no longer own the property, but I continue to own the income tax liability for that, which means that, let's say Liz is my darling daughter, I pay that income tax liability, which continues to reduce my taxable estate to the benefit of the assets that are outside of my taxable estate.
Wow.
And so in that way, I often call it like red dollars and blue dollars. Like red dollars are assets that are still subject to estate tax, liability. And so I have clients who've used up all their exemption, right? So let's say I've gifted $12.920 million to Liz in an irrevocable trust, and I still have a $100 million estate. So all that income that trust earns in 2023, I personally pay the income tax liability, even though it's a completed gift trust. I don't own the property anymore. I can't control it. But because of the way the trust is carefully drafted, I keep the income tax liability as the grantor. I continue to, sometimes they call it estate burn. Like I have the tax burn for that trust. So in terms of passing wealth on, your wealth is building in this trust that, let's say we put it in South Dakota, will go on forever. So the income continues to accumulate in there. There is income tax liability. It's just that the trust itself is not responsible for that income. The grantor keeps that income tax liability.
That is a great analogy.
And so that's how I continue to burn my red dollars and the blue dollars just continue to grow. Now, what happens if I still love you, but I don't want to pay that tax liability anymore, right? Because sometimes we're constantly balancing cash flow and income tax exposure, estate tax exposure. And all of this is driven by the client's goals and objectives. I mean, if you have a brilliant plan that doesn't meet the client's objectives, it's not a brilliant plan, right? It's all driven by what does the client want to accomplish? And sometimes, so we try to start with big picture, even if they're not ready yet. Even if today I'm not ready to give up $12.92 million, I can start with my well-designed trust with $20,000, with $100,000, with $500,000. And then you can keep making gifts. The grantor can keep making gifts to that trust. But going back to my question, if I don't want to pay that income tax liability anymore, typically would include a toggle where you can switch off the grantor trust provision, release those, and then the trust pays its own tax liability.
Okay.
Now, a completed gift trust, irrevocable trust, pays income tax liability at the highest marginal rate at a really low level of income. It's like $14,000 or something this year. So at $14,000 of income in the trust, you're skyrocketing to the highest income tax bracket, federal income tax bracket.
Right.
But if I already have a $100 million estate, that's not a huge concern. I mean, if you're already in the highest tax bracket, it's not a huge consideration. Precisely. But it is always a balancing. I mean, we are aware of these things. We try to make clients aware of all of these it's many factors to consider at the same time. And so we try to walk the clients through sort of one at a time. You can see that I go from hop around a little bit, and I want to be clear, but there are always a multitude of interests that
it's hard to talk
balancing.
about this in a linear fashion, right? It's definitely, I know
It is linear, and then you're like, but also all these other things.
Right.
So there's one other thing I wanted to talk about this trust. So let's say we've created this trust for you in Nevada.
Yes.
There are, as we've said before, there are 3 parties to every trust: the trust maker, the trustee, and the beneficiary. So if I make a trust for the benefit of Liz, a grantor trust, so I keep the income tax liability, but Liz is the beneficiary. So when it makes that income, it's available to the beneficiary for distribution. In certain jurisdictions, that trustee function, like I as the grantor have to give up control in order for it to be completed gift, to use my exemption, and have any growth be outside of my taxable estate, okay? And in some jurisdictions, that trustee function can be bifurcated into 3 roles. So it's split between, it's called a directed trust. Typically, I refer to it as a directed trust, but that trustee function is, there is an administrative trustee who is always, I would say always, I almost never say always, but always in the state where the trust lives. So you could have that administrative trustee in Nevada, and then the investment trustee or investment trust advisor, depends on what the statute says, controls, little c controls what investments are made. So if that trust got $1 million of business interest, earned $200,000 of income, as the investment trust advisor, which I can be even though I'm the grantor, I can direct how that $200,000 gets invested until I feel like Liz is ready to direct that investment herself, or maybe my spouse, if I pass first, my spouse could do, and then Liz could be her own. The person who designs the trust can decide who's going to be that investment trust advisor. But there's the situs trustee, the investment trust advisor, and the distribution trust advisor. The distribution trust advisor often is the same as the administrative situs trustee, but it can be somebody, it can't be the grantor. It can't be me.
Right.
And so we want to make sure that the distribution trustee or distribution trust advisor is a person that's going to comply with the federal tax rules, right? And often people will say like, oh, I don't want to give up the control of making a distribution. Or Liz will say, who do I need to ask for money?
Sure.
And often it takes my clients like a year to get comfortable in this new structure. And then it's like totally familiar to them. And so the distribution trust advisor, right? Even it's often the same as the administrative trust advisor. They can be fired. I mean, typically the grantor can, if they're going to deny you distribution, they're probably going to ask you what the distribution is for.
Right.
And if you say, I have a creditor who's coming after me for $50,000, they're probably going to say no.
As they should.
Right. And so
there is a discretionary element there.
There is, I mean, they it's not just in name only. They do have they do have to decide within the terms of the trust, is a distribution appropriate?
Yes.
But if you're asking for a distribution because you want to buy a Lamborghini,
right,
they might say, depending on the terms of the trust, if the trust says, if it's fully discretionary, they might try to redirect you, or they might ask whether we could lease it, or, ask if you want to rent it for the weekend first, right? But they probably are going to say yes. I mean, if you're trying to buy a house, typically as the trust attorney now, not as necessarily the grantor, I would want to say, if you want to buy a house, perfect. Let's find the house together and let's have the trust buy the house on your behalf, so that the house stays in this asset protected irrevocable trust.
Love it.
And the appreciation stays in the irrevocable trust. So if the distribution trust advisor is asking questions, it's typically to help you with strategically and say, like, let's talk with your planning counsel, or they're going to say, like, fine, and like issue the ACH, right? Send you the wire, send you the ACH.
Yes.
And if they don't, the grantor, I typically draft trust, so the grantor can remove and replace any of these roles. They have to be replaced with a Section 672C trustee who is not related or subordinate. So I cannot put in like my best, like kind of your best friend is not within that definition of 672C. So often people will put their best friend as the distribution advisor, but I won't put you probably as a remove and replace.
Right.
It's different who can be in that role first versus who can be removed and replaced. But I like to have as much distance as much sort of formality as possible.
Sure.
I mean, it's not always legally required. Sometimes they recommend more than is required. And if the client really wants something else, as long as it's going to hold water with the IRS, it's okay. But we want these structures oftentimes to work for a long time.
A long time.
And I want clients to be, as you will know, with any of these decision makers, you want it to be somebody who is a good person to make that decision.
Yes.
Not just because you have a fondness for them.
Exactly.
Or you don't want to not name them.
Right. And they need a skill set. You have to have somebody who has the skill set.
That's right. And so that's just the one other element of control. Where if Liz says, like, I'd rather have those $1 million of business interests myself. Like, no, you don't. Number one, if I gift those $1 million, if I'm the grantor again, and I gift $1 million of business interests to you in an irrevocable completed gift grantor trust, sometimes people call those idiots, intentionally defective grantor trust. It's not really defective. I don't design any trusts that are defective. But
isn't that a bizarre term?
They call it defective because of that wrinkle between the income tax liability and the estate tax liability. But it's not defective. It's by design. And it was initially actually that tax provision was put in to disadvantage people who were creating trusts because they were trying to create multiple trusts in order to reduce the tax load overall. Because if each trust didn't have the minimum tax amount at the time, they would pay less tax overall than I would with all that money. So they put in no matter what I do, if I have certain powers, I keep the tax liability. And of course, then like planners turned that on its head.
Yes.
And so like, this is actually amazing if you are in the high net worth category where you can burn down those red dollars.
Right.
I mean, nobody likes paying taxes, let's be clear.
Right.
Not any more taxes than are legally required.
Exactly.
And so burn down your own taxable estate by paying the income tax liability of a trust you've created for your, people that you love. But going back to that $1 million, if I put that $1 million of business interest into a completed gift, grantor, irrevocable trust for your benefit, in a site like Nevada, number one, is protected from creditors. So if there's, whether you have a car accident creditor or whether you have somebody that's just pursuing you for litigation, like those assets are for your benefit, to you or for your benefit. And if you have a creditor, a good trustee should pay things for your benefit instead of making distributions directly to you, which could be subject to creditors. I also believe that everyone should pay their bills. Of course. It's a litigious environment in general. And so trying to protect what you've built, if you're wealthy and you're a target, then we try to put in strategies in place that are, again, fully compliant with the law and administered according to their terms.
I would love to go off on a tangent about how we choose the trust situs, but maybe that's for another episode.
Sure. I mean, you want to look at asset protection laws.
Yes.
are often the length of the trust term. The state income tax rate is often a hugely, important factor. And then often those administrative trustees, like what is the availability of administrative trustees in the jurisdiction? And so if we have a few more minutes, I will circle back and talk to you about how crypto fits into that.
I'd love it. Thank you.
Do you think she's going to give us?
Yes.
Bear with us for a minute.
Yes. Bear with us.
And so with crypto, instead of that $1 million worth of business assets, right? If you're trying to transfer $1 million worth of crypto, what does that look like?
Yes.
Well, crypto is really broad. I mean, there's Bitcoin, there are stable tokens, there's other DeFi tools. So crypto itself is probably too broad. I mean, it's a massively broad category and getting more broad. There's also NFTs, which are very different, right?
Very different.
We have a lot of clients that have significant crypto assets. I mean, significant Bitcoin holdings. And so some of them who bought them for, when it was pennies. I mean, early. And they're often hodlers, which is hold on for dear life. And so the entire theory of that Bitcoin is really built on is sort of self-determination. And like it's a digital bearer instrument, which means that he who has the keys has the cash. I mean, it's often these, in a wallet, you have your wallet address. I mean, that's how you get into the wallet, whether there's cold storage, right? Or whether it's on a platform. If you don't have that key, if you don't have the private key, it's gone. I mean,
it's astounding.
And so just for basic planning, even foundational planning, making sure that like, do you know who knows where your key is? I mean, do you have it written down? Is it in a safe? Who has the code to that safe? Does your spouse know that you have crypto? If your spouse knows that you have crypto, does your spouse know what to do with crypto? Or your kids know what to do with crypto? If they don't, then you have significant crypto wealth. Do you want to name? We will name like an investment trust advisor in a revocable trust who will manage those assets for your beneficiaries if something should happen to you. But often when we have clients that have crypto that they were purchased for pennies on the dollar,
Right.
they will consider gifting some of it to an irrevocable trust because they already have a really low basis. I don't have enough time to talk about basis from the beginning.
Right,
The basis is basically where you start from in terms of assessing a capital gains tax on it, right? But if with a really low basis and a highly appreciated asset, you'll have significant tax exposure. If you transfer that to an irrevocable trust, they take your carryover basis. A lot of hardcore Bitcoin philosophists think like it's going, literally to the moon.
Right,
I mean, that it's going to continue to appreciate in value.
Yes.
And so they would, even with a high basis, they would transfer it to an irrevocable trust.
Okay.
In the grantor trust, we typically have swap powers. So we could exchange assets of an equal value over time. If you wanted an asset to be in your estate for basis adjustment, if you were going to have estate tax exposure anyway, and you're willing to swap that out. But the biggest concern is if you're transferring an asset to an irrevocable trust, like cryptocurrency, like a Bitcoin, you have to give it the control. And so how do you do that without giving the key to somebody, which they could run off with and empty the vault, essentially?
Isn't that the question?
And so there are, essentially, you want a trustee that you trust. And there are family offices a limited number of family offices that can be put in place to manage that. And so like they might hold one piece of the key, the trustee might hold one piece of the key, and then a third party might hold one piece of the key. But so there are ways to manage, but in order to comply and get that asset out of your estate for tax planning purposes, you have to give up control. You can't just hold the key entirely yourself, sort of self-autonomously.
Right.
So it's sort of always meeting those multiple objectives of like people who want to do the tax planning, but also then who don't want to completely give up their key. Like who can be the custodian for part of that key, who's going to be there in that moment that we don't know the day or the hour,
right?
For all those pieces to come together, sort of when this, and then once you have Bitcoin that's in an irrevocable trust, there are certain trustees who will lend it, so then they can create yield, so you get to hold the Bitcoin, but you can still generate income off of it. So I mean, I feel like you got more than you bargained for in this podcast, in the sense that there's many things that we could talk. I love talking to you about all these things, but at the heart of it, it's really, there's so much that can be done with good planning. And it's really hard to think about what would happen if you're not here, no matter what your level of wealth. But I do think that it's worth the effort. I mean, it's worth we do thoughtful creative planning, and that requires thought and conversation from our client and creativity and planning. And there is just so much you can do, whether there are charitable causes that you want to. Our entrepreneurs a lot of times they're worried about maybe their kids were growing up while they were building their wealth, like their grandkids. How do we plan for those qualitative values as well? Because the numbers, I talked a lot about the numbers and quantitatively, but qualitatively and values is probably where I spend more of my time. Like the numbers I can understand, but I spend a lot of time explaining them so that my clients can understand them.
Of course.
But the qualitative values are really important and drives all of it, right? Because otherwise it's just, money can be used for good or bad, right?
For sure.
And so the energy that the clients try to put into that and what they want to create without sort of holding the purse strings, but trying to create the best opportunity for whoever their beneficiaries is really at the heart of it. Well, it's usually expressed in many different ways, but that's really what we're trying to unearth. Is like, what is it that the client would love to leave as their legacy and as the sort of fertile soil for the next generation or their charitable beneficiary to sort of grow into with what they've been able to build in their lifetime.
Right. And I think that, my intention around having Julia on this episode and the discussion of high net worth it's not to overwhelm. It's to, and she said it so well, that you can start with a foundation. When you're building a house, you start with the foundation. And again, I love that she shared that it takes her clients sometimes a year before they're going to commit to releasing that, a high amount of assets in the planning process. So we all kind of suffer at some point in our lives from this analysis paralysis. If we overanalyze, well, how on earth am I going to protect my assets? How am I going to reduce taxes? You don't need to know all the answers. That's why Julia's here. So I know it can be a lot of overwhelming information, but you need to start at the beginning. And so, Julia, can you tell us how the listeners, if they needed to reach you, what's the best way to contact you?
Well, if you're in Arizona, you should definitely reach out to Liz.
Well, and I will tell you that I'm not embarrassed to say that any of our high net worth planning clients, we collab with Julia because she is an expert in the area. If we can use that term, I think we can loosely.
We co-counsel. Yes, that's right. I co-counsel with clients. And so I'm licensed in 5 states. But if you decide to trust in a state where I'm not, either where I'm not licensed, I co-counsel with attorney, or if their foundational plan needs to be in Arizona, we need their foundational plan to work in Arizona. Right. So we often co-counsel with lovely counsel that we just love working with.
Yes.
But you can reach out to me. I do almost all of my high net worth planning. I do with through my of-counsel relationship at Evergreen Legacy Planning.
That's right.
So they can reach out to me at jlc@evergreenlegacyplanning.com. And I'm happy to talk with you about your option.
Thank you, my friend, my esteemed colleague. I really appreciate it. This has been an episode for the books. Thank you so much for tuning in to the Estate Expectations podcast. Until next time, keep writing your story and keep planning your legacy.